5 seconds to go. Start. We have heard Shri Tushar Mehta, learned Solicitor General, appearing on behalf of the appellants, and Shri Sunil Fernandez, learned counsel, appearing on behalf of the respondents herein, original writ petitioners. Having gone through the impugned common judgment and order passed by the High Court has directed the appellants herein to determine and pay to the original owners the compensation under the Act 2013 on the ground that no award under the State Act of 1990 has been published and or declared. While passing the impugned common judgment and order, the High Court has relied upon Section 24(1)(a) of the Act 2013. Section 24(1)(a) of the Act 2013 reads as under: Land acquisition process under Act Number 1 of 1894 shall be deemed to have lapsed in certain cases. Notwithstanding anything contained in this Act, in any case of land acquisition proceedings initiated under the Land Acquisition Act 1894, where no award under Section 11 of the said Land Acquisition Act has been made, then all provisions of this Act relating to the determination of compensation shall apply, or where an award under Section 11 has been made, then such proceedings shall continue under the provisions of the said Land Acquisition Act as if the said Act has not been repealed. On fair reading of Section 24(1)(a) of the Act 2013, it provides that notwithstanding anything contained in Act 2013, in any case of land acquisition proceedings initiated under the Land Acquisition Act 1894, where no award under Section 11 of the said Land Acquisition Act has been made, then all provisions of Act 2013 relating to the determination of the compensation shall apply. Section 24(1) of the Act 2013 speaks about the land acquisition proceedings initiated under the Land Acquisition Act 1894. In the present case, the lands in question have been acquired under the provisions of the State Land Acquisition Act 1990. Therefore, the acquisition of the lands in question is not under the Land Acquisition Act 1894. It cannot be disputed that prior to the enactment of the Jammu and Kashmir Reorganization Act 2019 and promulgation of the Jammu and Kashmir Removal of Difficulties Order 2019, the Land Acquisition Act 1894 was not applicable at all, so as far as the state of Jammu and Kashmir is concerned. It is only on the enactment of the Jammu and Kashmir Reorganization Act 2019, Act 2013 shall be made applicable. It is the case on behalf of the original writ petitioners that as the provisions of the State Act of 1990 are pari materia to the Land Acquisition Act 1894, and therefore Section 24(1)(a) of the Act 2013 shall be applicable. The aforesaid cannot be accepted. The language of Section 24(1)(a) of the Act 2013 is very clear and unambiguous. It talks about the land acquisition under the provisions of the Land Acquisition Act 1894 only, and it does not speak about any other pari materia provision of different statutes. Stop.